This is a small attempt to help legal students or any other students who are studying intellectual property laws prepare for the future. I will try and answer some of the critical questions in each session, which hopefully will be helpful for study purpose. So today we will deal with the question, what is the meaning of copyright? What are the characteristics of copyright? So, meaning of copyright. The word copyright is derived from the expression copier of words, first used in the context according to Oxford Dictionary in 1586. The word copy is presumed to date back to Syria, that is approximate date 1485 AD, and was used to connote a manuscript or other matter prepared for printing. So word copy according to Black's Law Dictionary means transcript, limitation, reproduction of an original writing, painting, instrument or the like. So copyright according to Black's Law Dictionary is the right in literacy property as recognized and sanctioned by positive law. An intangible incorporeal right granted to the author or originator of certain literacy or artistic production, whereby he is invested for a specified period with the sole and exclusive privilege of multiplying copies of the same and publishing and selling them. Copyright, as defined in the Oxford English Dictionary, is an exclusive right given by law for a certain term of years to an author, composer, etc., or his assignee to print, publish, and sell copies of his original work. Copyright in some form seems to have been recognized in ancient times. The Roman law adjudged that if one man wrote anything on the paper or parchment of another, the writing should belong to the owner of the blank material, meaning thereby the mechanical operations of writing by the scribe deserved to receive satisfaction. Characteristics of copyright. Creation of a statute. So, copyright is creation of a specific statute under the present law. There is no such thing as common law copyright. No copyright can exist in any work except as provided in the section 16 of the Copyright Act of 1957. Form of intellectual property. A copyright is a form of intellectual property since the product over which the right is granted, example a literary work, is the result of utilization and investment of intellect. Monopoly right. Copyright is a monopoly right restraining the others from exercising that right which has been conferred on the owner of copyright under the provisions of the Act. Negative right. Copyright is a negative right, meaning thereby that it is prohibitory in nature. It is a right to prevent others from copying or reproducing the work. Multiple rights. Copyright is not a single right. It consists of a bundle of different rights in the same work. For instance, in case of a literary work, copyright comprises the right of reproduction in hardback and paperback editions, the right of serial publication in newspapers and magazines, the right of dramatic and cinematographic versions, the right of translation, adaptation, abridgment, and the right of public performance. Copyright only in form, not in idea. Copy is a sight given to or derived from works. There is no copyright in ideas. It is the form in which a particular idea is translated that is protected as copyright. Neighboring rights. Copyright consists not merely of the right to reproduction. It also contains or consists of the right to work derived from the original work. Rights like the right of public performance, the recording rights, and the broadcasting right, which are as important or even more than the right of reproduction. Such related rights are termed as neighboring rights. So thanks for watching. I hope you find the content useful and helpful. Let me know if you have any questions or feedback. So until next time, goodbye.